Hi everyone. I hope you're doing well and enjoying some of the grey weather that we're getting out here lately. If I'm only just going live, I've just said hello. As some of you may know, my name is Tharindu Alapola. I'm a senior paralegal and head of immigration at Temple Gate Solicitors. For those of you who haven't been following this series of immigration advice sessions, so Templegate Solicitors, we partnered up with the Group of Good Deeds charity, and it's them that have put together this special project really to help the people that are a part of this charity to obtain a bit of guidance in relation to your immigration circumstances in the UK. Now, you would have possibly heard from my colleague Andrea Houseman on Tuesday. She's usually there every Tuesday. I hope you found her session helpful. So during this live feed, I'll be looking to address some of the live questions that you post onto this feed. So I'll be looking to my left every now and again, and I'll continue looking over to my left because my screen is on my left just to see what questions come through, if any. um, so I mean, just want to say that we'll only be able to give out general advice. It's very difficult to give out very specific advice that may relate to your more specific problems without getting a complete understanding of the facts of your matter. Sometimes this requires a full consultation, where we really have to assess the facts and the circumstances of your immigration history, for instance, before we can really give advice that is tailored to you. But the whole point of this session is just to give out some general advice in relation to the questions that you ask. And obviously, if you want to discuss your immigration matter further with us, please feel free to send us an email or get in contact with the Group of Good Deeds charity, who will give you our contact details. You can always visit our website, which is www.templegatesolicitors.com. And obviously we'll do our very best to help you. We've had quite a few people contacting us already. We're always very happy to just have a quick conversation with people over the phone. Sorry, I'm just looking to my left. So yeah, we're always very happy to have a conversation with people over the phone. But obviously, if you need a more extensive consultation, then we will have to book you in for one. But yeah, whatever your problem is, do feel free to give us a call. So just, as a preliminary issue, we've been getting quite a few questions, and some of these are kind of topics that we've covered before. Some of these are questions that were asked during Andrea's session. It's really to do with those people, those migrants who have entered the UK. And they came here on a limited visa, which means that they may have come here on a visa such as WISDA visa, which was due to expire, a short period after they entered, and they then eventually became stuck in the UK, unable to fly back to their home countries because of the coronavirus. So what do you do when that happens? Well, the most important thing you have to do is, if you're currently in the UK and you can't extend your existing visa and you have no way of leaving the country, then you must go online and fill in the Corona visa extension form, which you can find on the .gov.uk website, or we can put a link into that if you need. And you must extend your stay, and you're granted. I mean, pretty much everyone that has applied, I believe, they have been given an extension up until the 31st of July. It usually takes about 5 working days, sometimes a bit more, for the Home Office to get back to you. What other people have been doing is, where they are in the UK, for instance, on a visitor visa, and they had plans of maybe returning or exiting the UK and making an entry clearance application, for instance, to subsequently come here as on the spousal route as the partner of a British or settled person. So people that had a plan to leave the UK and then apply to enter the UK on an entry clearance visa, you can effectively now make that application from inside the UK because of the coronavirus. And I suppose you will be allowed to do this up until the 31st of July. Up until that date, you wouldn't be making an entry clearance application from inside the UK. What you would essentially be doing is making an application for further leave to remain under the the appropriate category for you. So for instance, if you're planning on making an application for entry clearance on the spousal route and you're currently in the UK, unable to leave the UK in order to make that entry clearance application, you could effectively do an application for further leave to remain in the UK under the spousal route, which is, it will be the first time, I believe, from my understanding, it will be the first time that entry clearance applications would, be would be made from inside the UK. Although it's not an entry clearance application, like I said, it would be an application for further leave to remain. But it does give you quite a lot of flexibility in being able to apply from inside the UK. It may save you some money in terms of your travel costs and everything else. Thank you. I'm getting some comments through, and hello everyone. Thank you for sort of tuning in and for also posting your questions. I can see that there is a question that's come through. It says, please let me know what I do I 4 months ago I apply visa spouse. I get visa 1 month to come to UK, but now flight. My visa finished last month. I am still in Nigeria. What to do? Extend my visa in Algeria? This is quite tricky. So you left the UK with a short period of time left on your spousal visa, and you are unable to return to the UK, and your visa has now expired. If your visa's now expired and your passport is currently with you in Algeria, the only thing I can think to do would be to make an application for entry clearance to re-enter the UK. So, it wouldn't be too different from the application for further leave to remain that you would have made. So I'm guessing your initial spousal visa would have been for 2.5 years. And before the expiry for that 2.5 years, you would have been looking to extend that for a further 2.5 years. I'm not quite sure whether you're on the 5-year route or the 10-year route to settlement, but either way, whatever evidence and documents you are looking to show the Home Office in your application for further leave to remain, you would now do an entry clearance application from Algeria. And you would put in the same evidence and the same documents, and obviously you would have to try and meet the requirements of the entry clearance application. If you're not able to meet the requirements of the entry clearance application for any reason, and it's because you're in Algeria and not in the UK, you would have to explain that in a covering letter when you submit your application. But if your visa has expired and you're currently not in the UK, you wouldn't be able to re-enter the UK on an expired visa, I'm afraid. You would have to apply for that entry clearance before you enter the UK again. And of course, any difficulties you have in doing that, you have to explain that to the entry clearance officer at the point of making an application. And of course, that's done, like I said, by way of a covering letter. So we have another question. Rashid, I hope that answered your question. Again, if you need a little bit more information, feel free to contact us. So there's another question that's come through by Sarah. Hi, I have indefinite in the UK and I want to apply for British passport. How long are you going to be? I'm guessing what you mean is if you've already been granted indefinite leave to remain in the UK, you generally have to wait up to 12 months before you can apply for naturalization. The rules say that there must not be any time restrictions on your existing visa at the point that you apply for naturalization as a British national, and that you must have remained in the UK on that visa with no time restrictions for at least 12 months before you apply for naturalization. Of course, if you have ever overstayed in the UK for any reason, if you have ever committed any sort of a criminal offence and been charged for it, or if there's anything at all which may bring your character into question, then the period of time that you're required to wait before you can apply for naturalization may be different. For instance, there are some people who have come to the UK, they eventually become an overstayer, they remain as an overstayer so as an overstayer I mean, they generally don't have a visa, or any sort of status in the UK, but they managed to regularize their stay. So they eventually managed to get some sort of legal status in the UK. They managed to get a visa or whatever it is that gives them a legal status in the UK. They then continue on that route, and eventually they come to apply for naturalization, having been granted indefinite leave to remain. What they usually find is that the application for naturalization may be rejected because they previously overstayed in the UK. So you've got to be very careful about that if you have previously overstayed. So if you had previously overstayed, even if you've been granted indefinite leave to remain, you would generally have to wait up to 10 years. I know it's a long period of time, but that's how long you may have to wait before you can make a successful application for naturalization. I hope that's answered your question, Sarah. If you need any further help, please contact us. Right, okay, perfect. I think there's a few more comments coming through. And yep, if there are any other questions, please do let me know. So until some other questions come through, I was just commenting on what to do if you are currently in the UK and if you're stuck in the UK without a visa. And I was explaining that you should fill in the online application form issued by the Home Office. And I was also explaining that there are now options where you can effectively make an entry clearance application by way of a further leave to remain application from inside the UK, where you would normally have to make those applications from outside the UK. Another topic that I want to just quickly touch on is the no recourse to public funds policy. A lot of people contact us about this. A lot of people get confused about whether they're entitled to access public funds, and by public funds I generally mean benefits. The usual rule is migrants who are granted leave to remain in the UK don't have access to public funds until they're granted indefinite leave to remain. It's usually after you being granted indefinite leave to remain or permanent residence, whatever you call it, that you usually have access to public funds. People that are on the European route, so on the settlement route or pre-settlement route, may have access to certain public funds. And now, a couple of weeks ago, I did sort of raise this new case that had been successful, and what that case, the outcome of that case means that if you're currently in the UK as the parent of a British or settled child, then you may now have access to public funds. You know, for the Home Office to restrict a parent of a British child access to public funds may be unlawful. So if you have been granted leave to remain in the UK, or if your status in the UK has been regularized as a result of your relationship to a British or settled child, then you should now have access to public funds, i.e. benefits. If you don't, and if your biometric residence permit or whatever immigration documents you have states that you don't have access to public funds, then you may want to get in touch with either your local council or with an immigration consultant to get this changed and to basically make a request on your behalf so you can access public funds if that's what you want to do. So there's a couple more questions that have come through. Let me just see what they are. What is the current English test required for indefinite leave to remain? So you usually need to achieve a level B1, I believe it is. I'm just gonna put a link in the group if you need more questions about that. So there are approved SELT testing centers, and you must get your English language test through an SELT, a secure English language testing center. when you get that, you must get a qualification that's at least the minimum level that you must get is a level B1 or a level B2. Obviously, if you get anything higher, C1, C2, that's all very good. If you studied for a degree in the UK, or if you've got a degree that was taught elsewhere outside the UK, but it was taught in English, and you can get a letter from what's called UK NARIC to confirm that it was taught in English, then you may not have to take an English language test. Similarly, you may be exempt from the English language test if you come from a majority English speaking country, right? Again, what I'll do, I'll put a link for you, Ali, that may help you with that question. I'm just going to reply directly to your question. I hope this comes through. Right, sorry, I'm not very good with this, but I hope this does come through. So moving in from that, there's another question that's come through from CM. If you came to the UK on a spouse visa and got divorced 4 years after marriage, but 2 years since arrival to the UK, do you have to leave the UK? If you came to the UK on a spouse visa but got divorced 4 years after marriage, but 2 years since arrival, I mean, so you've only been in the UK, so I'm guessing your spousal visa is granted for 2.5 years. Generally, if you're on the 5-year route, you have to complete 5 years to settlement. Your marriage ended 2 years after you came to the UK, so 2 years into your spousal visa, I'm assuming. Because your relationship broke down, technically your spousal visa will also come to an end. It should be curtailed. Your spousal visa is granted to you on the basis of your relationship to your spouse. So you know, one of the main requirements for your spousal visa is that you have a genuine and subsisting relationship. The moment that your relationship breaks down, or the moment that you get a divorce, then one of the main categories or requirements for that visa ceases to exist. If it then ceases to exist, your visa ceases to be valid. You've been in the UK for 2 years at the point of the divorce, which means that when you come to apply for an extension of your visa at the 2.5-year point, you're going to have a very difficult time showing that you're in a genuine and subsisting relationship, given that you've gone through a divorce. And you'll probably find that you're not able to extend your visa, or even if you come to the point of applying for indefinite leave to remain, you still have to show that you're in a genuine and subsisting relationship. So I'm afraid, without being in a lasting relationship, your visa also ceases to be valid. I'm really sorry about that. If you are currently in the UK on this route, you should be looking to switch into another route as soon as possible. Alternatively, if your visa has already come to an end, then you should not remain in the UK as an overstay, because it could lead to all sorts of larger complications in your immigration history. Yeah, and you should essentially try and leave the UK and then apply for entry clearance to re-enter the UK under a different route if that's available to you. Unfortunately, once relationships do end, it does leave applicants in a very difficult situation. I'm sorry I wasn't able to give you a more positive answer than that. So there's another question by Seha. So someone has been granted a refugee stay, and next year their 5 years are going to be completed. Is this safe to apply for ILR? Generally, yes. I mean, your refugee status, so when you're granted refugee status, you should be given a letter from the Home Office, and it should explain to you when you become eligible to apply for indefinite leave to remain. Some people are granted asylum, other people are granted humanitarian protection. Other people are granted protection under, well, I suppose different European human rights laws. So depending on the route that you're given, and some more, other people are granted discretionary leave. So their asylum cases may have been refused, but they may have been granted some other sort of discretionary leave to remain. So depending on the route that you were recognized as someone that needed protection, you would have been given a qualifying period that you need to achieve before applying for indefinite leave to remain. So if you want, what we can do is, if you email us, if you email us with whatever ARC card, BRP card, or Home Office letters that you have, we'd be happy to sort of take a look at that and let you know exactly what your qualifying period is before you are eligible to apply for indefinite leave to remain. I think without seeing those documents, I don't want to really confirm what your qualifying period is, because I've seen that it changes depending on the category under which you've been granted protection in the UK. So the next question, there is someone from Sihem. Oh, Sihem again, I'm sorry. So you meant she arrived 2 years after the marriage and is on the 5-year route. Oh, I see. So would you mind, I'm a little confused by whether you arrived in the UK or whether your spouse arrived in the UK, and who's the actual British national and who's the actual immigrant. I think what would be great is if you contacted us, so I can get a bit of clarification on your question, if you still need that, that is. So Sarah says, do you have any idea about when the Home Office, when they are going to reopen, if they are working from home, what are they taking so long for making decisions? So yep, from my understanding, the Home Office are open. We've been receiving decisions from the Home Office. We've been receiving decisions from the tribunal service and the court system. The Home Office are still accepting applications. They're making decisions on applications and other submissions which were submitted before the whole coronavirus took place. But I'm assuming that most Home Office officials are working from home. If there are people working from their office spaces, they'll be working at a very limited capacity. So things are very much delayed. What we've found are currently there are delays with people receiving their biometric permits or ARC cards, because all the sort of offices that print these cards aren't functioning. So they are functioning, but they're functioning at a very limited capacity. So you may find that there are delays at every stage. Of course, if you need to submit an application for further leave to remain or even entry clearance, you can still submit those applications. Remember, you can still submit those online applications. So even if it's a paper-based application, there's nothing to stop you from filling it in, attaching your documents and posting it. But what you will find is that there will be delays in you providing your biometrics, and where you made an online application, there'll be delays in you being able to provide your documents to support your application, because most of the UK VCAS centres are either closed or operating at a limited capacity. I understand that quite a few UK VCAS centres have now started opening up again, but it's very difficult to get an appointment with them. Because they're opening, they've opened, but they've opened with a limited capacity, so they're only taking on a few appointments every day. So I hope that sort of answered your question, Sarah. There's another question here from Sarah again, Sarah, but sadly that letter has been lost while moving a few years ago, so that's why I have concern about what to do, how to get that letter back from the Home Office. Seha, I think the best thing to do, you can make a data subject access request. So it's a freedom of information request. The Home Office is a public body. As a public body, they have an obligation to release any information that they hold on you to you upon request. So you need to make a request to them. It's usually called a data subject access request. This is something we can help you with if you need. Otherwise, there's nothing to stop you from making this application to the Home Office and requesting that you be provided with a copy of everything that they hold on file for you. If you've lost a Home Office document that has important information on it, this may be the best way of trying to retrieve a copy of it at least. Seha, I hope that's helped you somewhat. So I have got another question here from Ram Raum. Does the lack of comprehensive health insurance interfere in the citizenship application for EU settled status immigrant? I'm so sorry. Um, it could do, is the answer to that. It depends on what treaty rights you've been exercising. So where you have been employed, so whether, yeah, I mean, I'm sure you'd be aware. So in order to be recognized as a European migrant with a either settled or pre-settled status here, you effectively have to show that you've been exercising some sort of a treaty right. That treaty right could be that you're studying, working, that you're self-employed, operating a business, or that you're even claiming benefits. Where you're not working or operating a business or self-employed, so where you're not paying taxes essentially, right, you would have to show that you had a comprehensive health insurance policy in place. A lot of people run into trouble when they come to apply for their extensions or settled status, or even their pre-settled status, where they haven't taken out this comprehensive health insurance. But I think they are a bit more relaxed on this rule now, ever since the new Home Office pre-settled and settled status application came into place. So they may not be so strict with the comprehensive health insurance requirement. But from what we've understood, and I can look into this a bit more actually, just to see if that requirement is still stringent. But if you are here without, and you haven't been paying taxes, so for instance, if you've been here as a student, exercising your treaty rights as a student, then you should have had comprehensive health insurance, and you may run into trouble when you come to apply for settled status if you haven't had that. I hope that answered your question. Again, please feel free to contact us more if you need more information. But Arum, if you can send us an email, I'd be happy to look into that a little more, just to see if that requirement is still there, and to send you an email with a bit more information. So there is another question, I believe. It's from Sarah. It's been only 4 months that I've had my interview, but no answer. So, I see. This is with the Home Office. Sorry, I think 4 months is understandable right now. A lot of people haven't had answers ever since the whole. I mean, I think end of February, beginning of March is when, everything came to a standstill because of the COVID-19 virus. The Home Office are functioning at a very limited capacity, so there are delays. Yes, we are getting decisions, but there will be delays. And I expect you may be waiting several more months before you are called in for an interview or before a decision is made on your application, whatever it is. But yeah, you will be waiting some time, I'm afraid. So things are working at a very limited capacity. So I think that's most of the questions so far. Of course, if you have anything more, please do feel free to ask on this group. I think during Andrea's session there were a few questions about what other services we provide. So there was a question about document legalization. So Templegate Solicitors essentially, we specialize in immigration law and in family law. Andrea's, I mean, if you've got a problem that's a hybrid between immigration and your family circumstances. So if you're, for instance, I think the one question that came through that relates to a divorce plus immigration circumstances, Andrea would be a great person to talk to because she's a specialist in both family law and in immigration law, and she's got many people's successful results with their family matters as well as their immigration matters, of course. But yeah, Templegate Solicitors do specialize in both family and immigration. But another service that we provide is document legalization. So this is where people have obtained documents that have been issued by a UK body, whatever it is, a university, a council, a marriage registry, and you need to get that document legalized for use abroad. Usually it's for use abroad, but you may have your own reasons. Where you do need a document legalized, have a look on our website. This is also a service that we can provide for you if you wish. I'm only saying this because there were questions about this during Andrea's session. So yeah, if you need any help with either your family law matters or your document legalization, in addition to your immigration matters, please contact us. And there's another question that's come through. Sarah, yes, with lockdown forever, we don't know. But look, Boris Johnson, he's easing down on the lockdown rules now. So, now I believe people will be able to go, and if people living alone can go and stay at a family person's house or a loved person's home, and they can actually stay the night, and that's going to be the new sort of easing of the lockdown rules come Monday, I believe. So we are seeing a gradual easing of the lockdown rules. So what that will mean is that it won't be too much longer, I think, until the Home Office and other government departments start opening up again. We've seen the gradual reopening of the Foreign and Commonwealth Office. Up until last week, they were completely suspended with only urgent applications being accepted. But now they're actually starting to accept normal applications again too on a limited basis. So we're seeing the gradual reopening of government bodies and institutions. Of course, the Home Office, if you're stuck in the UK and you came here, for instance, on a visit visa, or if your visa came to an end and you have no way of extending it, the Home Office will extend that visa, or it will extend your stay up until the 31st of July this year if you make that online application. So that date, the 31st of July, I think it's an indication as to when the Home Office believe things may go back to normal. So we may see the Home Office reopening on a larger scale from the 31st of July onwards. But of course, that all depends on how this whole virus plays out, whether it gets more serious or whether it continues to die down. And hopefully it will die down, and hopefully we as a society can continue to go back to normal. So there's another question by Fafa. If someone has been granted asylum for 5 years, what you can do after 5 years finish? Thank you. Usually after 5 years on asylum, you should be able to apply for indefinite leave to remain. Again, I would have a look at the documentation that you've been given by the Home Office at the point of being granted your refugee status. When you're granted that status, that letter that you're initially given usually tells you what your qualifying period for indefinite leave to remain is. So yeah, please refer to that letter. If you need a bit more help sort of figuring that out, just get in contact with us so we can ask you a bit more information about how you managed to get your asylum, under what category you were granted protection in the UK, so we can figure that out. Sarah, I'm glad that it's helped you. It's always good to know that these sessions do help people and they do answer questions. Ram, thank you for your email. We'll look into that, and as soon as one of us can, we'll get back to you with some information that will hopefully help you. Sorry, I've got a very coarse voice today. I feel like I'm not speaking properly. So Amina asks, can someone who came to the UK as a visitor, tourist, be granted leave to remain because she is a mother of a British child, plus she has had domestic abuse? If you're currently in the UK under either a visit visa, or even if you don't have a visa, if you have a child and that child is British, then yes, you should be making an application for leave to remain as the parent of a British child. Those applications tend to be quite strong because even though the rights of families and the rights of or the best interests of children have eroded away gradually and quite badly in the last few years, in the last 10 years especially, there is still a recognition of a right to a family life in the UK, and also the Home Office do take into consideration the best interests of children and what it would mean if children were separated from their parents. Of course, if your child is British, your child has every right to reside in the UK and to be in the UK, and that right should not be interfered with, is our argument. And your removal as the parent of that child, if you are removed, that would interfere with their best interests, and it would also interfere with their rights to stay here, remain in the UK without any infringements. So I'm also sorry to hear that you've been a victim of domestic abuse. If you've been a victim of domestic abuse, there are other options available to you. Of course, you would need to prove that you were a victim of domestic abuse. But there are, I mean, if you are a victim of domestic abuse, I would recommend that you approach a legal aid agency, a legal aid law firm, or there are some really great charities. One charity that comes to mind is Rights of Women. Rights of Women, they're a charity. They help lots of women who have gone through domestic abuse, and they also help with their immigration circumstances and provide them with advice where they've been victims of domestic abuse. So what I'll do is I will have a look for the link for Rights of Women. They're a great organization, and I'll put a link for the organization. Here it is. I'm just going to put a link for that organization in this chat as a comment. Hope it helps. So Amina, if you want to talk to someone about the domestic abuse element, please do contact Rights of Women. But if you need help in terms of your application to regularize your stay here as the parent of a British child, then that's certainly something we can help you with. And yes, you do have a route here, and it would be a strong application, I believe. So the link is just there. Hopefully that will come through. There it is, rightsofwomen.org.uk. Feel free to contact them, Amina. They will help you. And you're on the 10-year route. Oh, you've already applied, right? Okay, so you're on the 10-year route. So I'm not quite sure what your question is. I mean, I'm sorry. So if you're on the 10-year route, are you looking, I think you may be just looking for advice about the domestic abuse, possibly, and not really in relation to immigration matters. So yes, please do contact the Rights of Women charity. They will be able to help you with that. But again, like I said, if you need help with the immigration element of your query, please feel free to contact us, and we will try and help you with that. Someone here says, Al Amina, I want to know if there is any free fees for 7-year applications. I think what you mean by the 7-year application is possibly that you have a child that was born in the UK and they've established a private life in the UK through residing in the UK for 7 years or more. There is a fee attached to this application, but you can ask for a fee waiver. So what you'd need to do is, before you make the application, you'd need to first, there's an application that you make to the Home Office before you make your application, and you ask them to exempt you from having to pay the fee. Other than that, there is a fee attached to it. Some people would say make further submissions. Further submissions are generally done where you've made an application of some sort already. So in this case, Amira, if you made an application to regularize your child's stay in the UK and that application was refused, you can then do something called further submissions, which doesn't cost, it doesn't carry the same fees of an application, but it's not as secure a way of applying for this route as making the normal FLR application. And I say that because when you make an application, when you make further submissions, you're effectively making them to a separate department and immigration officials that have a lot more power and a lot more discretion over the decision that they make. Whereas when you make an application, as long as you fulfill the requirements of the application, you're generally expected to be granted leave on that route. Of course, if you're not, and they made a decision which is incorrect or unlawful or wrong, you can also appeal that decision. You should be given appeal rights if you make fresh or further submissions too, but again, it's a bit more tricky than a straightforward application. But you may find that you can save a bit of money if you make further submissions, and you can only do that if you've already made an application on that basis before. There's another question here from Yemi. Can a visitor with multiple entry visa that will expire in November 2020 convert to spouse visa if he has stayed over 108 days and got an extension till 31st July? Actually, Yemi, yes. The answer to that is yes, and it's only yes because of the current circumstances with the coronavirus. Normally, you're here as a visitor. A visit visa normally does not give you any option for extending your stay. either on the visitor route or any other route. If you want to switch from the visitor route to another route, normally you'd have to leave the UK and apply for entry clearance. But because of the coronavirus, the Home Office have published some new rules which say that if you're currently in the UK and you're unable to leave and you want to switch into another category, a category which normally requires an entry clearance application, such as the application you're asking for, you can now make that application from inside the UK by way of a further leave to remain application. Right? You still have to make sure that you fulfill all the requirements of the rules as if you are making an entry clearance application. The sort of documents and evidence that you have to put forward are pretty similar when you're applying for entry clearance under the spousal route, as well as when you're applying for further leave to remain. Little differences may be that the English language requirement, for instance, you only have to do a level A1 when you're applying for entry clearance, whereas when you're doing your extension you need a level A2. But even though you're doing a further leave to remain application which requires an A2, you can still get away with a level A1, for instance, because it's your first application and you're making that application in place of an entry clearance application. So we've been doing a few of these lately, people who've been stuck in the UK, who've been trying to switch into another category from their visitor route. So they've been here, they've come here as a visitor, they're stuck in the UK and they want to switch into a longer term visa. Normally it's not possible, but right now, and I'd say up until the 31st of July, there will be a window open for you to make those applications from inside the UK. I hope that answers your question, Yemi. And again, if you need any help doing that, please feel free to contact us. And I think there's a question from Chen that says up. I'm not sure if I've missed a question here. Sorry, Chen. Let me have a look. No, I don't see that I have missed anything. Maybe I'm just misinterpreting your message there. Amina, you're welcome. I'm glad I've been able to help, if at all. So yes, if there are any more questions, please feel free to sort of post them. I've got another 10 or 15 minutes, I think. But in that time, oh, there's another one that's just come through. Can my wife apply with English test certificate even if it's expired? Because most centres are closed. Thank you. If the centres are closed and you currently have to make an application right now that requires an English language certificate and you're not able to get one, make your application without the English language certificate, right? Put in a covering letter, explain that you're not able to get the English language certificate because of the centres being closed, because of the coronavirus, right? That's very important. Lots of people are having to make applications without English language certificates right now. Don't put in an expired English language certificate. There's no point. It's expired, doesn't hold any value. You could maybe put it in just for the sake of adding a bit of goodwill to your application, I suppose. But what could be more useful is, I know some English language testing centres have now started accepting appointments. So some clients that we know have managed to get appointments. Of course, the appointments are set for much further in the future. So at the point of making your application, if before you submit it, make an appointment for whatever's available at any sort of English language testing centre. Of course, it has to be an SELT, a CELT centre. English language certificates, whatever level it may be, that's not from a CELT centre, a secure English language testing centre, are generally not accepted. So please make sure that whatever centre you do go to, it's a CELT centre. So my advice is book your English language test if you can, and you'll probably get an email or something confirming that you've booked your test. Just put a copy of that email in with your application, just to show them that you're doing everything that you can to get your English language certificate. But again, the important part of your application would be putting in that covering letter, putting in an explainer as to why you haven't been able to get it. Of course, the Home Office should be understanding of the fact that people aren't able to get their English language certificates, their Life in the UK tests. If you're making entry clearance applications, you wouldn't be able to get your TB certificates. All of these are now things that can't be helped. Of course, there are circumstances outside of your control, and because of the fact that there are circumstances out of your control, just put in a covering letter, explain your circumstances to them. And I hope that's helped you. Girl, of course, like I said, if you need anything else, please feel free to contact us. I'm just trying to think, if there are any other topics that I can address. I think during Andrea's session, not this session but previous sessions, there were questions about the Tier 4 route, about students, and I did cover that in my subsequent sessions after Andrea got given those questions. So I did do a bit of a section. But if there are any students again that need help, please feel free to contact us. So I can see, I think the questions have pretty much died down, so I will probably put an end to this session now. Thank you very much, everyone, for tuning in. I hope this has been helpful to you. I hope my sort of lecture here has been clear and comprehensive. And if there is anything else you'd like to get a bit of help on, just contact us. My colleague Andrea, she will be here. Andrea Hausman will be on this session, on this page, doing her session on Tuesday, 4 p.m. Again, it might be helpful for Andrea if you could email your questions beforehand, and it will be helpful to all of us, actually. If you have any questions, feel free to just email us either beforehand, or if you're not able to answer your question fully during our sessions, again, please feel free to email us and we'll do our best. Thank you very much. I hope you all have a pleasant day, and I hope you take care and stay safe. Bye-bye. Bye-bye.